Rights of wife to Mutaah after divorce in Malaysia will be presented by Group 2A in Islamic Family Law. Meet the group. We have Al-Falah, Nur Salinda, Nur Afza and Anis Maisara. Islamic Family Law, Federal Territory Act 1984, Section 56, Mutaah or consolatory gift to women divorced without just cause. In addition to her right to apply for maintenance, a woman who has been divorced without just cause by her husband may apply to the court for mutaah or consolatory gift, and the court may, after hearing the parties and upon being satisfied the woman has been divorced without just cause, order to the husband to pay such sum as may be fair, just according to hukum syara.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Al-Falah bin Fazmi and you can call me Falah. Now, let us proceed to the issue for our case study. The issue for our case study is whether the divorced wife can claim the muta'ah to the ex-husband. To answer this issue, we have been prepared the cases, the judgment of the judges. Our opinion, either we agree or disagree with the judgment of the judges, and also the ways how to improve the situations, and lastly, the conclusion for our case study have been prepared by us. Start with me, followed by Anis, Afza, and lastly, Linda. I'm going to talk about the two cases that I have studied. First case is between Noraini binti Abdul Rashid versus Datuk Hamzah bin Zainuddin 2005. In this case, Noraini binti Abdul Rashid represents the plaintiff and Datuk Hamzah bin Zainuddin represents the defendant. These both couple were married on 2 May 1981, and after 15 years of marriage, they were divorced on 2 December 1996 by the pronunciation of divorce outside and without the permission of Sharia court. They have 4 children. So, on top of that, the plaintiff played her role to claim muta'ah amounting to 3 million ringgit. However, the defendant, who is Datuk Hamzah, disagreed and sued her for nushuz. The court held that the argument from the defendant is unreliable and cannot be used because the argument of the defendant is just based or relies on the hadith, merely on the hadith, without considering the predicaments and hardship of the plaintiff to take care of their children at home alone before. So, the court held that the argument of the plaintiff can be used, but the argument of the defendant was adopted. Therefore, the court held that the plaintiff can claim the mut'ah amounting to 810,000 ringgit. The second case is between Hazrina binti Hamidin versus Muhammad Zaidi bin Majid 2005. In this case, Hazrina binti Hamidin represents the plaintiff and Muhammad Zaidi bin Majid represents the defendant. These both parties were married in 1997 and they had 3 children. However, on 2 July 2003, they were divorced by the pronouncement of 1 talaq in Sharia court. The plaintiff applied for muta'ah in the amount of 7,000 ringgit to the defendant. However, the defendant contended that although they divorced in a good way, as the plaintiff filed for fasakh divorce in the Sharia court and through negotiation, it was initiated by herself and not from him. The court held that the plaintiff was eligible for the muta'ah. Why? Because the fasakh divorce was clearly pronounced in the Sharia court. even though it lays under fasakh divorce. The defendant denied her claim on behalf of Mutaah. It is because the defendant said that he did not do anything until she, who is the plaintiff, filed for fasakh divorce. However, the plaintiff argued with the statement of the defendant. The plaintiff said that the defendant often uttered vulgar language toward her and acted immorally, which in contradiction with the Sharia. Therefore, of the last argument for this case, the court justly ordered for the defendant to pay the mut'ah in the amount of 3,500 ringgit to the plaintiff by installment in the amount of 100 ringgit per month until it is settled.
So the next case is Zainun binti Osman represented the plaintiff and Wahid bin Ali represented the defendant. Plaintiff and the defendant were married on July 15, 1995 at the Naratiwat Islamic Religious Council, Thailand. They divorced on January 10, 2005 with one talaq pronounced. The divorce occurred outside the court and without the permission of the court. The plaintiff demanded from the defendant Mutaah payment a sum of 200,000 ringgit, to which the defendant disagreed. Instead, the defendant offered the plaintiff a sum of 22,500 ringgit but was refused by the plaintiff. As regards the status of the plaintiff, she was from an ordinary family and was the cousin of the defendant. Before their marriage, the plaintiff worked as an administration supervisor in BMES company in Bandar Seri Damansara, Kuala Lumpur. Next, the parties had 3 children from the said marriage. After their divorce, the children had been under the care of the plaintiff. Meanwhile, the defendant at the material time was a retired general manager of the State Electricity Board and had received a sum of 680,000 ringgit from TNB and in 2005 as retirement benefits. Further, the defendant received a pension of 1,000 per month from TNB. In determining the mut'ah rate, the court was satisfied after considering 4 criteria that had been determined by Hukum Syara in the cases referred to. The mut'ah that the plaintiff was entitled to receive is a sum of 40,000 ringgit Malaysia. As for its payment, after considering the situation of the parties, the courts ordered the defendant to pay mut'ah on an installment basis of sum 500 ringgit Malaysia per month, effect from April 2012 until its full settlement. In conclusion of this case, the wife has the right to mut'ah in the event of divorce caused by the husband, such as divorce through talaq. The husband cannot indiscriminately release the responsibilities entrusted to their wife as determined by Allah Subhanahu wa Ta'ala, whether during the marriage or after the occurrence of divorce. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Afza binti Muhammad Fakrurazi. My matric number is 064910. Today I'm going to discuss 2 cases that I've studied and provide some feedback on. The first case is Nordia Juri versus Ahmad Zulkifli. Nordia Juri was the plaintiff in this case and Ahmad Zulkifli was the defendant. They married joyfully on 8 August 1986 in Federal Territory of Kuala Lumpur and were divorced on 6 February 2003 in Petaling Jaya Subordinate Court after a 60-year marriage. As a result of their life together, they have a child named Ahmad Danish bin Ahmad Zulkifli. As a result, the plaintiff played a role in claiming the Mutaah of Rm 500,000 ringgit because she was divorced without cause. The defendant, Ahmad Zulkifli, disagrees, claiming that his salary is barely Rm 37,000 ringgit and 100, and that the divorce will tarnish his reputation. Before deducting income tax, the defendant said that he only made 30,000 ringgit. Finally, the court determined that the plaintiff arguments were accepted and the defendant arguments could not be used. As a result, the court determined that the plaintiff is entitled to Rm 1,085 ringgit, 85 and 500 ringgit in Mutaah from the respondent. Chaitun B alias Zaitun binti Muhammad Yaakob versus Muhammad Taha bin Wan Ahmad is the second case. The plaintiff was Chaitun B, while the defendant was Muhammad Taha bin Wan Ahmad. The plaintiff in this case claims Mutaah under Selangor's Islamic Family Law Enactment of 1984, Section 56. The plaintiff is seeking Mutaah in the amount of Rm 420,000 based on the defendant's monthly wage of Rm 10,000 ringgit. However, the defendant claims that his monthly earnings are only 500 ringgit. After 35 years of marriage, they divorced because she was sacrificed by herself as a wife with 4 children, and the plaintiff was never declared nushuz. Finally, while the plaintiff's reasons were accepted, the court found that the defendant's arguments could not be used. As a result, the court concluded that the defendant is liable to pay the respondent Rm 2,000 ringgit in Mutaah.
Assalamualaikum warahmatullahi wabarakatuh. I am Nosalinda binti Mansur with metric number 063681, and today I would like to tell to you about 2 cases that I have found about Mutaah, which are, the first one is Murshida binti Mustaqim versus Hasim bin Abdullah, who had been divorced on 7 April 1990 by one talaq outside the court, which was recorded on 24 November 1990 in Federal Territory Kuala Lumpur. However, the appeal was dismissed and the Sharia High Court's verdict was upheld. Okay, then for the second case is Ainun binti Abdul Aziz versus Roslan bin Abdul Rashid, as she became the second wife after receiving permission by the Sharia Court in Ipoh. However, because of the defendant's irresponsible behavior, their divorce was finalized on 4 February 2002, as he pronounced ta'liq to his ex-wife. So the application of Mutaah and the maintenance of iddah was granted. So the defendant have to pay 3,000 ringgit Malaysia for Mutaah to his ex-wife. In conclusion, ex-husband should pay Mutaah according to the rate or amount that had been decided by the Syariah High Court, and he should be fair with his wife for after this. That's all. To conclude all those cases, Mutaah is a gift from a former husband to his ex-wife. Depends of his ability and the wife behavior and the ex-wife behaviors and her family criteria taken. And Mutaah will be given if the husband who is the one wanted to divorce and not the wife. For me, thank you.
Based on the judgment of judges in each case, we have been agreed with their brilliant decision and realistic judgment because they got their right to claim muta'ah from defendant. There are also ways to improve, which is husband and wife. They have to solve their household problem well and ethically. The husband should also give the wife sufficient muta'ah right to cover up the shame and support her life after the divorce. In Surah Al-Baqarah, verse 241, state that, and for divorced women is a provision according to what is acceptable, a duty of upon the righteous. Next, the defendant should prioritize paying the muta'ah adequately, as Allah Subhanahu wa Ta'ala said in Surah Al-Baqarah verses 236. Provide for them the rich according to his means and the straitened according to his means, a fair provision. Last but not least, husband and wife should manage their problem and having a talk heart to heart before getting divorced, because there are cases that wife has been divorced without any cause.
To conclude, Muta'ah can be defined as a consolation that must be given from the husband to the ex-wife as an appreciation to the woman for them to start a new life. However, the divorce cannot be caused by the wife. So all the cases are related, as all the plaintiffs who are being ex-wife wanted to claim muta'ah for themselves. A divorced wife is entitled to maintenance provided as the wife is divorced by talaq raj'i. Not only that, a pregnant wife who had been divorced by talaq ba'in is entitled to alimony until the child is born. However, non-pregnant women who are divorced by talaq ba'in are not entitled to alimony, clothing and shelter. However, they are entitled to housing facilities and a wife who is not nusyuz. Wives who are in iddah due to the death of their husbands, and wives who are divorced but have not had sexual intercourse are not entitled to iddah maintenance. All the wives who had been divorced can claim in nafkah iddah too. So, most all the ex-wives taking part on claiming properties such as a house and others. That's all from me. Thank you.